The hard drive last week that had 431 PDF files, 98 videos, and 94 images. That was the requested discovery that I had asked for back on July 25th. So I have not yet had a chance to review all of the.
I appreciate the fact that you said I will turn on the hard drive later in the day, back in July, and you did it. Sometimes people will say, I have a hard drive now, so I appreciate that. So how much time are you asking for to review that?
Judge, 30 days if court would allow.
All right, Ms. Ferguson, I need a 30-day reset.
And Your Honor, also, I've already filed motions on this case.
I just want to, excuse me, sir. Here's the thing. Do you want your attorney to go without having reviewed anything? What he has to review is a lot for him to review. If you want your attorney to go to court blind and be surprised by whatever the state presents, you can do that. But you're not his only client. So the fact that he has all of that to review, he needs to review it to be effective for you. You may continue.
Judge, I filed 17 motions on this case. One is a motion to suppress. The other is a motion to reduce bond. And at the courts.
17 motions in 1 week. This lawyer didn't just work. He basically lived in Microsoft Word. Motion to suppress. Motion to reduce bond. This tells the audience something big. The defense is gearing up for a fight, not a quick plea.
I'd like to schedule those as early as possible.
All right. So, state, with regards to the motion for the bond reduction, have you had a chance to review that, and would you be ready to proceed on that?
I'll see that. If I look at a judge, I can be prepared for it.
All right. So we may be able to take up the motion for bond reduction to you. The motion to suppress, I know the state is not going to be ready for that because I'm assuming there will be witnesses needed.
Absolutely, Judge. The judge will need, I'm sorry, the state's going to need at least a week, I think, to be ready for.
All right. Because I'm assuming it's not just search warrant where I can read it and say yay or nay. So we're going to come back on September 29th. Is that good for you? All right. And then state on September 29th, you haven't done so, you'll need to be able to tender offer on that day. And an acknowledgement of discovery will be need to sign on that day. All right, so if y'all have a seat and if you'll confer with them on the bond, the court will hear the bond matter.
Sure, Your Honor.
You're welcome. All right, the court is calling 2025 CR 004887. State one, Alberto Martinez. Could I have parties announced for the record?
Seriously, dear, and for the state, Your Honor.
Robert Featherston, representing Mr. Martinez.
And you are Mr. Martinez? All right, your attorney has filed a motion for a bond reduction. State, have you had a chance to review the motion?
Yes, Your Honor.
And do you waive notice?
Yes, Your Honor.
All right. So according to this, your client is charged with manufacturing, delivery, controlled substance penalty group 1. Let me see. Is it over 400 grams?
That is correct, Your Honor.
Over 400 grams. The bond is currently set at $25,000, according to your motion, and you're asking for the bond to be reduced?
That's correct, Your Honor.
All right. Do you have any witness?
Over 400 grams of a penalty group 1 substance. Just to put that in perspective, that's the top-tier level under Texas law, the kind where sentences start looking like phone numbers. So a $25,000 bond? Honestly, that's on the low end. No wonder the state is side-eyeing the reduction.
No one is selling Mr. Martinez.
All right. Could you raise your right hand? Do you solemnly swear or affirm the testimony you give will be the truth, nothing but the truth, so help you God? All right. You can lower your hand. State your name for the record.
Alberto Martinez.
All right. Counsel, you may proceed.
Thank you, Your Honor. Mr. Martinez, you have a great concern about a family member. Who is that?
My mother was diagnosed with cancer a week ago. And she personally been doing a lot for me. So my patients may be turned over. I mentioned the discharge.
And here's where the courtroom mood shifts instantly. The defendant brings up his mother's cancer. And whether the audience believes him or not, emotion always hits differently in bond hearings. Judges can't legally lower a bond just for sympathy, but they can consider humanitarian factors when deciding PR eligibility.
I'm pleading to the court. And then the way that you all told me, I mean, I'm willing to do anything you would say, but I am my mom's oldest son. She doesn't deserve to die alone. But I am listening to Sean, but I would plead no contest to the court. Whatever, how I can get probation, whatever information you put, whatever. So whatever.
This is
No,
not
no, but I understand
fine for
that I have
causation.
that's the problem with my mother. She got that. That's what it's saying. My grandmama.
You're right, please report, he's under a great deal of stress because of this issue with his mom. He originally started with the PR bond and then his bond agency asked for a bond increase as a result of some issues associated with his bond. I think Steve will probably go into more detail on that. But we're respectfully requesting that the court consume a PR bond on him. There is no violence involved in this particular case. And he would like to be able to provide some assistance to his mom. Now, pass it.
Right,
I don't really have any questions.
Yes, for this.
all right. So, does he have any fun?
Young, I'm appointed to his case. He is independent. And I do not think that he has any funds that he can draw on, considering what has now happened to his mom, which was his sole source of income prior. I don't think he's going to be able to come up with any money in order to be able to get him out on a bond. He has no bank accounts, no personal property, no real property. To rely upon in order to get anything on the
Oh. So what I'm going to do then is you're saying there's no amount of bond he can make. He needs a PR bond. Is that correct?
Yes, sir.
All right. So in this case, Ms. Ferguson, have him evaluated for a PR bond. And once the evaluation is complete, we'll have him brought back. It shouldn't take that long.
Not in the most time that I've got the court.
All right. So, Norm, I want him evaluated for a PR bond, and then we'll place him back on the docket as soon as completed. It should be done by next week, hopefully.
I'm judging.
All right. Thank you. Ade? All right. Yes.
Well, we had a discovery. There seems to be what so you get got a perfume that was the top. Would be very helpful. I believe it. You see all this story out two little stuff with how it's important. I believe the client wanted to address what the following gets you off.
All right. So, do you want a jury trial or a bench trial?
Man, look, I feel like I'm being coerced into fighting for something that.
Now, here's the thing. Let me explain the process to you, and I want you to hear me and internalize what I'm saying. So anytime somebody is charged with a criminal offense, once it works its way to the DA's office, they'll review it. They may take it to the grand jury. Once the grand jury indicts the case, which doesn't mean anything, it doesn't mean you're guilty, it's just telling what you're charged with, it gets assigned to a court. And then you get assigned an attorney. You're probably assigned an attorney before it's even indicted. Then your attorney will make sure that they have all of the discovery. So what is the discovery? The discovery is usually everything that the state says they have in order to prove that you committed this offense beyond a reasonable doubt. That's the way they look at it. That's the way they say, yep, we have enough evidence. In this court, I take it a step further. Once your attorney has told me that they've received all of the discovery, I make sure that the state tenders an offer. Now, the state's offer can be whatever they want it to be.
This right here is one of the clearest explanations of plea bargaining you'll ever hear. The judge breaks it down like she's teaching criminal justice 101. Discovery, offers, counteroffers, jury versus bench. But pay attention. She's also sending a message. Don't confuse fairness with getting the deal you want. A lot of defendants think the system is railroading them simply because the offer feels harsh.
They're supposed to be seeking justice. That's what it says in the code. So, whatever they offer you, that's what they're offering you. Your attorney will present that offer to you. You can say, I'm not accepting that, which is called a rejection. Or either you can say, I want to accept this, but I will accept this. And then that's called a counter offer. Your attorney is ethically required to give that counter offer to the state. And the state can either say, nope, we're not doing that. The only thing we're offering you is what we previously offered you. Then you have a choice to make. Your choice is either you're going to accept that offer, or either you're going to go to trial or not. Either you're going to do a jury trial or a bench trial. So railroading, whatever you feel railroading is, if you feel railroading is the state is not making an offer that you find acceptable, then to you that's railroading. But they make their offer, and then once they make their offer, you have choices to make. So if you want a jury trial, and this court will give you a jury trial. If you want a bench trial, a lot of people think that they get to determine, yeah, I want a bench trial, therefore I get one. But the state has to agree also and say, it's okay for you to have a bench trial. What a bench trial is that I, or the judge who's sitting here, will hear whatever evidence is presented and make a decision on whether you're guilty or not guilty. Jury trial, there'll be 12 people sitting in the box. 12 random people, right? They'll sit in the box. The state will present their evidence to that jury, or either to the court if it's a bench trial. They'll do that by calling witnesses. Witnesses will come and testify. Hypothetically, normally, this is what usually happens. The state has to prove that it happened in Bexar County. Because if it didn't happen in Bexar County, then I don't have any jurisdiction. They usually have to prove an on or about date. And they do on or about dates, so you'll know we're talking about on or about this date. This is when we're saying it happened. If it's a robbery, guess what? Complainant will come in and complainant will say, certain items of value were taken from me without my consent, which means I didn't give this person permission to take my things. This person took my things. And usually a robbery involves some type of physical force. You know, if somebody is walking around with a purse and you snatch their purse, maybe that's a theft of a person, but it could potentially also be a robbery. It just depends on the way it's charged. So that's what the state has approved if it's a robbery case. If it were a drug case, they would have to bring in a chemist to say, yes, these are drugs and these are illegal substances. And then somebody would have to prove that you're the person who possessed the drugs or had care, custody, and control of it. So that's where we are. So if you are not going to come to an agreement with the state, then your next setting is going to be a jury trial. And you will be brought over dressed in whatever clothing you have at the jail. If you wish to be brought in any other civilian clothing other than what you have at the jail, you'll need to sign a release so clothing can be brought. So, do you want a jury trial or a bench trial, or are you reaching an agreement with the state?
The reason why I don't want to take what the state is offering me because I don't want, I don't think prison is.
Here's the thing. Let me just tell you. Whatever the state is offering you, I'm not involved in what their offer is. But what I can tell you is, if you look over in that box, I guarantee you nobody in that box will raise their hand and say that they think prison is right for them. I've had people, when I was a defense attorney and when I was a prosecutor, they would be charged with murder. They're like, prison's not a place for me. Nobody thinks prison is a place for them. You may once every 200 cases have somebody who'll say, yeah, I deserve to go to prison. But normally people don't say that. So I don't need to hear about your negotiations with the state because ethically I'm not supposed to hear about that.
They're not even trying to hear me. He's not even trying to hear me. That's what I wanted to do.
Okay, so state on this case was Jacob. All right, Jason. All right, Mr. Andrade is informing the court that he wants a dismissal. Are you going to dismiss this case?
No, I'm not saying to dismiss the case.
All right, so he wants something other than what you're offering him. Are you intending to offer something other than what you've already offered?
Yes. Right. I prefer no, Judge. That's the offer.
All right, so he said he's not going to change the offer that he has made.
In fact, Judge, sorry to interrupt you.
No.
That would be today on the offer since.
All right.
You guys have really true.
All right.
I feel like I got an ultimatum. I feel like I hired another lawyer to be, I have a better chance. You know,
And there it is, the ultimatum moment. The defendant says he feels trapped, and that's extremely common when the state says, "This is the offer today, tomorrow it's gone." It feels like pressure, and it is pressure, but it's completely legal. This is the psychological battlefield of plea negotiations most people never see.
the drug program because the whole reason why I'm not running from what I did. I think I wouldn't take what I don't really don't you know say something. Your Honor, you are studying others. Sometimes think about this. I know Jason is leading.
So today is the day you make your decision. If you don't want to accept the offer, then it's going to jury trial or either bench trial. So sit in the box, and then I'll bring you back up at 10:30, and you need to let the court know whether you're accepting, if you've reached an agreement, or whether you're going to jury trial. Those are your options. Right. Jacob Andrade.
Yes. This was not finished. That's on account. We went to the attorney, and we would ask this time to go to a jury document.
All right, Ms. Ferguson, I need a jury trial date. How long do you expect this trial to last, counsel? Hold on.
3 days, Judge.
All right, Norma, 3 days. And it's criminal trial division. Counsel, you make sure I have an acknowledgement of discovery. I think I may have one, but just double check.
That was tendered on Tuesday.
All right, October 28th.
And boom, it's official. No deal. No middle ground. We're going to trial. The judge locks in 3 days for a full-blown courtroom showdown. This went from a simple discovery hearing to a full legal escalation. And if you've watched enough of these cases, you know, trial dates mean the real story is just beginning.